There are fewer public companies today than there were 30 years ago. So against that backdrop, there are companies for which going public through a traditional IPO is not an option. I had a relatively naive notion that transactional work is not adversarial. While certainly true that the interests of your counterparty are typically not as diametrically opposed as they are in a litigation, it's still quite adversarial. So the adversarial nature comes in terms of how to allocate risk as between the two parties. First firm said something that really stuck with me and said that if you orient your thinking as an associate as the partner's there to help you get the deal done as opposed to the other way around, it really helps you anticipate and to be proactive, because the key to getting better at anything is practice, practice, practice. The only way that you're going to gain the substantive knowledge is getting the reps in.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a corporate partner who approaches the art of the deal with the same precision and discipline he once applied as a violinist at Juilliard. He has charted a path through the top tier of the legal world as an analyst at Cravath, an associate at Shearman & Sterling, and now as a partner at Ellenoff Grossman. He is a master of complex M&A and alternative public offerings, advising clients across industries ranging from cryptocurrency to healthcare to chemicals. It's my pleasure to welcome Trevor Okomba to the podcast. Welcome, Trevor, and thank you for being here.
Thank you for having me. I've been looking forward to this.
Likewise, Trevor. So, as you know, I love to start by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
I will start with a cringe joke and tie it in with a fun fact.
That sounds great.
First, the cringe joke. How do you get to Carnegie Hall? Practice, practice, practice.
That's a nice throwback to your early days. That's great. Thank you.
And a fun fact that follows from that joke is that I've actually had the privilege of performing as a violinist at Carnegie Hall on a few occasions. So I can attest to the fact that a great deal of practice is in fact required to get there.
That's amazing. What sort of performances were these?
Yeah, so I performed as a soloist once as part of a Vivaldi concerto for 4 violins. I also performed as part of the filming of a movie called Music of the Heart. There was a scene that took place as a performance in Carnegie Hall. And then the final performance was a chamber music performance.
That's amazing. Are there any YouTube or other archives on the internet of any of these?
So you can still find the New York Times review of one of the performances online. Otherwise, no, obviously the movie, you can watch the movie, but otherwise, no.
That's great. Well, what we might actually do, Trevor, is actually link to that in some of the show notes, just as a source of an additional piece of knowledge about you and your sort of past career and past qualifications. So that's fantastic. Which is a great segue into my next question, which is obviously today you've practiced music, but now you're to sort of follow up on your cringe joke, you're practicing law, right? And so I think of every attorney who makes the time to be on this show as a superhero, and every superhero has an origin story. And given where you started from, I would love to hear sort of what drove, how you sort of had that moment of transition from where you were to where you are today, and then of course your remarkable trajectory in the years since.
Yeah, sure. So I'll trace my professional journey starting with the path that led me to law school and then go from there.
Sure.
So during high school, I developed a relatively uninformed interest in potentially becoming a trial lawyer. I read the book Civil Action, which really captured my imagination. It's a legal drama about a tort litigation involving a water contamination case against a large chemical company. It pitted a small law firm against this massive corporation, a real David versus Goliath story. And that sort of captured my imagination. But towards the end of college, I began to revisit this idea of going to law school with a more pragmatic view, geared towards what I thought my strengths were in trying to figure out what I would be good at. And I think at the time, I had a relatively naive notion that transactional work is not adversarial and might be a better fit for my temperament. While certainly true that the interests of your counterparty in a transaction are typically not as diametrically opposed as they are in a litigation, at least in the context of an M&A transaction, it's still quite adversarial. I graduated from Princeton in 2010 with a bachelor's in politics. And again, my interest in law school wasn't as fully formed as I would have liked before sort of making that decision to go to law school. I took a 2-year interlude prior to going to law school to work at Cravat in what was essentially an administrative role. But through that role, I was able to gain some exposure to the transactional work that they did, what life at a law firm looked like. And just as importantly, it also left me some time to study for the LSAT. So I think my interest legal career really matured during that period. I was able to develop a more informed view as to a potential career path. After those 2 years, I went to law school at the University of Pennsylvania Law School, graduating in 2015. During law school, I summered at Sherman and Sterling, which is now known as A. Sherman after the recent merger. And then upon graduation, joined the firm as an associate. I'd say my time at Sherman was really instrumental to my development, not only as a practicing attorney, but just generally as a professional. I think that the benefits of working at a large law firm like that are pretty well documented, but just the training, the exposure to high profile deals, and the resources devoted to professional development was very, very important to my development as a junior associate. And I would say that at the time I had envisioned perhaps remaining in private practice for a few years and then transitioning to do something else, perhaps go in-house. But my time at my current firm really energized me and is part of the reason that I became partner and continue to practice. So, I could speak a little bit about my current firm and sort of what's been exciting to me and what's motivated me to make that transition to partner. Ellenoff Grossman Schole is a mid-sized law firm of approximately 150 lawyers based in New York with offices in California and a presence in Israel. The firm is relatively young, founded in 1992. It's a firm focused in the corporate practice areas, including mergers and acquisitions, public company advisory work, capital markets, intellectual property, among others. And one of the things that's been the most exciting about my career at AGS has been the entrepreneurial nature of the practice. It's provided me with the opportunity to both continue practicing with the support of a sophisticated platform with the added flexibility of working at a firm like AGS. For example, from billing arrangements or the way that we staff deals provides the flexibility to attract a broad range of clients. And it's been a really exciting period. When I joined the firm a little over 6 years ago, we were a firm of 70 lawyers. And today we're a firm of 150 lawyers. So it's been an exciting period of growth, strategic growth, which has really kept me energized.
That's amazing. Thank you for sharing that. The sweep of your entire journey so far, Trevor. That's really remarkable. A few follow-up questions as I was following along to all the things that you were sharing. So first is, what were some key lessons that you would say you learned in your first role post-law school as an associate at Sherman? And then how did those translate into you landing the role at EGS? And then what are some of the sort of lessons that you've learned during your time at EGS?
Sure. I touched a little bit upon sort of the broad ways in which the training was beneficial, from working at high profile transactions to being able to take advantage of some of or many of the professional development resources provided. I think if I had to point to one of the overarching lessons that I learned and that's really stuck with me was really taking ownership even from a junior level, really taking ownership of not only the tasks that you're working on, but really trying to anticipate and feel as though the deal that you're working on is truly your own. So someone, my first firm said something that really stuck with me and said that if you orient your thinking as an associate as the partner's there to help you get the deal done as opposed to the other way around, it really helps you anticipate and be proactive about what's going on. And that's not to say as a junior associate, you're going to have the answers to everything or that you're really going to know how to do everything on the transaction. But if, for example, an email comes in that's directed towards the partner, don't ignore it. Take a look at it, see if you can offer your thoughts, and really take advantage of the opportunity to contribute in any way that you might be able to. So I think the idea of really taking ownership of the entire process was something that helped me at the beginning of my career when perhaps didn't have all of the substantive knowledge, but at least I could show that I was thinking through things and trying to be as proactive as possible.
Yeah, that's such a great line to as an associate to think that the to imagine that the partner is there to help you, because then that flips everything on its head. It's like, hey, I'm sort of at the center of this, and if I put myself in that mindset, I would even argue potentially, and you let me know what you think, is that it almost elevates the way you think about it, and you might think about it at a higher level, at a more strategic level, even accounting for the fact that there's differences between in skills and experience between an associate and a partner. But just having that, I think, is that's such a great line. And then the second is, I would imagine, Trevor, that having the crucible for building that mindset within your prior firm as an associate, essentially what you're doing by taking ownership is you're essentially becoming entrepreneurial within that domain. And so I would imagine that would have served as a pretty good launching pad and less of a cultural adjustment as you move to a firm that is maybe somewhat smaller in size, but still has tremendous impact. Is that a fair statement?
Yeah, I think that's a fair statement. And I think one of the ways in which transitioning to a more boutique law firm is you feel a bit more ownership of the wins. And fortunately, we haven't had many losses, but also the losses. You really feel as though you're contributing to the firm's success. Whereas you're at a larger law firm with massive institutional clients, as a junior associate performing due diligence, while yes, you want to have the mindset of taking ownership of the deal, it does sometimes feel as though you're one of many.
Absolutely. That's great. Thank you for sharing your trajectory throughout over the past decade or so. Let's talk a little bit about your firm as it stands today. So, as I understand it, EGS is known as the market leader for SPACs and alternative public offerings, and these are areas of law that are essentially, at least to a non-lawyer and non-financial person, and essentially financial innovations. And so, the kind of work that you do, can you maybe talk a little bit about it, and also talk about what is the role of SPACs and alternative public offerings in the context of what most people understand? What role do they have, and what is the regulatory structure that you have to work in when you have these offerings?
Yeah, sure. So I'll start with a brief 2-minute primer on what a SPAC is to orient the conversation, and then I can speak to those issues. So the SPAC, as you mentioned, is an alternative way to taking a private operating company public. It could be an efficient way for a company to access the public markets. And the process can be broken down into 2 steps. So the first step involves taking public the acquisition vehicle. So in order to do so, a group of investors, which I'll refer to as the sponsor group, will partner with an underwriter to raise a sum of money, let's say $100 million, or the public company, which will remain in a trust account until the SPAC closes on the acquisition of the private company. Upon that closing, that private company becomes the public company. And the sponsor group is typically comprised of, it could be private equity folks or venture capital folks or former C-suite executives. But the ability to raise the money at that initial IPO on desirable terms is largely dependent on the quality of that group. So the market needs to have confidence that this group can find a good deal. Before I move to the next step, it's important to note that the sponsor group also has to put up risk capital of several $1,000,000 to fund the operations of the SPAC, because that $100 million that I referred to has to remain in the trust account and can't be accessed by the SPAC until the closing of the business combination. So the sponsor group could potentially lose that risk capital if the SPAC is unable to consummate a transaction. So that's the first step. Then the second step, after that acquisition vehicle has gone public, it has a set period of time, typically 2 years, to find a target and consummate what we call a business combination, essentially the acquisition of the private company. And that private company becomes a publicly listed vehicle. Now I can speak to sort of where the SPAC fits in sort of the broader economic environment. So to frame that answer, let's just start with the fact that there are many businesses that can benefit from accessing the public markets. For example, there's been a lot written about the backlog of companies in private equity looking for an exit, and there are fewer public companies today than there were 30 years ago. So against that backdrop, there are companies for which going public through a traditional IPO is not an option, whether they may have a control structure that doesn't work for an IPO, or the IPO window isn't open, the timing it doesn't work. For certain companies, the SPAC instrument provides a solution to that issue, but it's important to recognize that it's a solution to a given circumstance. So it's not the right tool for everybody.
Got it. I knew of some of the mechanics of SPACs, but some of the details that you mentioned there were valuable for me, and I'm pretty sure will be valuable for our generalist legal focused audience as well. Can you talk a little bit about some of those circumstances under which a SPAC makes sense versus does not make sense for a business owner who might be in a position where they're thinking of accessing the public market?
When you think of a private company looking for an exit, there could be a few options, right? You could sell to a strategic, which could be an attractive option from maybe a value perspective, or you could sell to private equity, which can be a very quick process. I think for a company that can't access a traditional IPO for some of the reasons that I had mentioned, going public through a SPAC can be quicker. It can be a faster process. Sure. So yeah, SPACs can be a better option for some companies for a variety of reasons, including you can access the public markets quicker in a SPAC than a traditional IPO. There's also upfront price discovery. Your price in an IPO depends on market conditions at the time of the listing, whereas in a SPAC transaction, you negotiate the pricing of the SPAC before it closes, which is much more advantageous in a volatile market.
That makes a lot of sense. Thank you for putting your banker hat on there, Trevor. So now, if I may ask you to put your lawyer hat back on, what are some of the legal considerations that come up in your experience when you have the sponsor group and then when you have the company that they're found? What are some of the considerations that come up and that you're called upon to address?
Sure. So I think that there are, in the context of the second part of the SPAC transaction, so in the portion of the SPAC process where the public vehicle is making the acquisition of the private company, it is essentially a M&A transaction, right? So the public vehicle is acquiring a private operating company. So you have what we refer to as a business combination agreement, which is the definitive agreement that governs that acquisition. And there are typically heavily negotiated provisions in that agreement. So for example, one condition that is often heavily negotiated is how much cash is going to be required at the closing in order for the parties to be obligated to close. In other words, a minimum cash condition. So the public vehicle raises a bunch of money, goes out and acquires or signs an agreement to acquire the target. But at the closing, the public investors have the option of redeeming their public shares. So it's often negotiated, what is the condition to actually closing on that transaction? There are also other typically negotiated provisions that are not specific to SPAC transactions, like the reps and warranties, the carve-outs for the reps and warranties, interim operating covenants, things like that. I think that in the SEC portion of the transaction, so in order to get approval from the SEC to list the shares of the public company, you have to go through the registration process where, similar to the disclosures you would make In a traditional IPO in S1, there is a Form S4, which includes disclosures about the private company as well as about the transaction. And there are nuances, which would involve a much longer discussion. There are nuances in the differences between the S1 and a traditional IPO and an S4 and a de-SPAC transaction. But generally, the process is similar in that you have to submit to the SEC and get through their comments for effectiveness of that registration statement.
One of the things you mentioned earlier on in our conversation, Trevor, was that initially you entered this space thinking that maybe M&A is perhaps not as adversarial as some of the trial lawyer matters or litigation that's out there, but you sort of implied that it is. So what are some of the key areas where you see maybe some of this adversarialness, maybe some strong negotiations? I know you alluded to a couple, but can you just maybe elucidate a little bit for the benefit of our audience?
I think that depending on the type of transaction you're working on, there are provisions that are generally more heavily negotiated than others. So I touched upon one of them in the context of a SPAC transaction, which was the minimum cash condition. So I think my point in comparing litigation to transactional work in terms of how adversarial those two areas are is that while ultimately the two parties or more in an M&A transaction are ultimately working towards the same goal, which is to close a transaction, the interests of your client are not aligned um, precisely with those of the counterparty. So the adversarial nature comes in terms of how to allocate risk as between the two parties.
That's great. Thank you for sharing. Trevor, your experience with SPACs and alternative public offerings spans a broad range of industries. I just listed a few in the introduction: cryptocurrency, healthcare, chemicals. You've also done mining, transportation. What are some of the, at a high level, key similarities and or key differences across these industries that you've seen that stand out to you?
I think there are different considerations for the various sectors, whether it's typically if it's regulatory, for example, there are different considerations from a due diligence perspective. You need to be sensitive to what sort of specialized diligence you need to carry out. So I think that there are sort of high level differences from how you would conduct a transaction in the various sectors. But I think from a legal perspective, in terms of negotiating agreements, there are typically, as I had mentioned, provisions are typically heavily negotiated, and that's sort of common across sectors.
Got it. You mentioned due diligence, which obviously would make a considerable portion of any sort of M&A deal, right? And so I would imagine that there is some level of technology that is used, and even AI that is used in the due diligence operations that these firms, the sponsor groups, conduct, and maybe that you're involved in. How, in your experience over the past decade or so that you've been practicing, have you seen technology be a more and more critical part, if at all? And of course, now with the advent of AI, in sort of conducting due diligence and in either accelerating it or maybe creating new considerations that you now have to deal with. What's your general take on technology and AI in this role?
Yeah, sure. So at an institutional level, there are tools that we use on a firm-wide basis for certain tasks. For example, due diligence. There are ways in which folks use tools on an ad hoc basis to supplement their work. So, for example, whereas a few years ago, folks may have started with a Google search to point them in the right direction on a task, now they turn to ChatGPT. So ultimately, I think AI is a tool to supplement our practice, but it hasn't replaced what we do, at least not yet.
This is true. No, that's great. This has been a great conversation, Trevor. Just one question for you, that relates to your own career trajectory and all the things that you've done up to this point, and that I'm sure you'll continue to do. So, you became a partner relatively earlier in your career, relative to compared to somebody who's traditionally in big law. And so, for any sort of younger, ambitious lawyer that's out there, what guidance or advice would you have for them in terms of what is the one key skill or group of key skills that they would need to have to have a mastery over if they want to make that jump to partner and follow perhaps a similar trajectory like the one that you have been on?
I would go back to what I had been discussing earlier about taking ownership from day one. I think that if you're proactive and really try to anticipate the needs of, well, in the first instance, the partner you're working with, because as a junior associate, your client is the senior associate or the partner that you're working with. If you try to anticipate their needs and anticipate what's needed on the transaction and show that you're thinking holistically, I think that will put you in a great position while you gain the substantive knowledge, right? Because the key to getting better at anything is practice, practice, practice. The only way that you're going to gain the substantive knowledge is getting the reps in. But if you can take ownership from day one, that'll put you in a position while you're getting the substantive knowledge.
Amazing. All right, Trevor. So final question for you. Is there a question that I should have asked you, but I didn't?
My pick for the Super Bowl?
Please, yeah.
What's it? So I grew up a Jets fan, so I have to root against the Patriots. Don't go with the Seahawks.
Oh, okay. Sounds good. Yeah, we will see. Good luck to both teams. All right, Trevor. Well, this has been a wonderful conversation, very informative. I enjoyed speaking with you, and I'm sure our audience will have learned a lot as well. So thank you so much for your time. I really appreciate it.
Thank you for having me. This has been wonderful.
Great.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.